having fun in a fucking cop car.
Yep. Tristan.
What's up, guys? Tristan, if you fucking walk out the damn...
What happens when the justice system determines that a teenager should face the harshest penalty, death?
Myers is one of two men who strangled and stabbed 18-year-old Justin Back last January.
In today's video, we're diving into some of the most haunting and controversial cases where young offenders were sentenced to death or life without parole for crimes that stunned the world. These stories go beyond legal debates. They challenge us to question the morality of condemning adolescents to die in prison or face execution. From savage murders to devastating mass shootings, each case reveals the troubling intersection of youth, violence, and justice. At just 19 years old, Austin Myers was sentenced to death in Ohio for the brutal 2014 murder of Justin Back. The quiet town of Waynesville was left reeling after Myers and his friend Timothy Mosley plotted to rob Justin, a recent high school graduate. Under the guise of a friendly visit, they entered his home, but their plan quickly turned violent. When an attempt to strangle Justin with a wire failed, Mosley stabbed him more than 20 times. The two then wrapped his body in a blanket and dumped it in a remote septic tank. In addition to the murder, they stole valuables including a safe and set parts of the house on fire in an attempt to destroy evidence.
His trial took weeks. His verdict was handed down in hours.
We, the jury, find Austin Gregory Myers guilty beyond a reasonable doubt of aggravated murder as charged in count 1 of the indictment.
During the trial, prosecutors highlighted the calculated and cold-blooded nature of the crime. The defense argued that Myers wasn't the one who actually killed Justin and that he hadn't intended for him to die. They emphasized his age, clean record, and developing brain, yet the jury didn't accept those arguments. The careful planning, attempt to destroy evidence, and Myers' lack of remorse were seen as aggravating factors that far outweighed any mitigating ones. Ultimately, Myers was convicted of aggravated murder, robbery, and tampering with evidence, leading to his death sentence in 2015, making him one of the youngest in Ohio to face execution.
Killed 18-year-old Justin Back in January of last year.
Obviously, we're satisfied. We think that justice was served today.
Myers and Mosley carried out a planned burglary at Back's home, strangling the Waynesville High School graduate and dousing his body with septic system enzymes before dumping it in a wooded area.
The verdict today makes it unlikely that Austin Myers will ever...
The sentencing ignited intense ethical debates over whether it's justifiable to impose the death penalty on someone so young. Experts and advocates emphasized that at 19, the brain is still developing, particularly in areas tied to impulse control and long-term judgment. Neuroscientific research was brought up during appeals, arguing that Myers didn't fully comprehend the consequences of his actions. Nevertheless, the Ohio Supreme Court upheld the death sentence. To this day, his case remains a focal point in legal and academic discussions surrounding capital punishment for juveniles.
A 19-year-old from Warren County, now the youngest person on death row in Ohio.
The idea that he has no worth or value as a human being, so better off euthanized.
For the brutal murder of a friend.
We have memories, but we will have no more with our son because of the choices that you made, Austin.
And tonight, a bombshell revealed in court.
He wanted to kill.
No, I've made a horrible mistake. I'm only 19 years old. I think there's a lot of good things I can do with my life if you allow me to keep my life.
In 2020, Marlon Joseph was sentenced to death in Florida for a crime that shocked the entire state, the cold-blooded murders of Kalada Crowell and her 11-year-old daughter Kyra Inglet. The tragedy unfolded in 2017 inside the home they shared. Joseph, who had been in a relationship with Crowell, reportedly flew into a rage during an argument. What followed was pure horror. He pulled out a gun and shot Crowell in the head. As young Kyra tried to run for her life, Joseph chased her down and shot her multiple times, even as she begged for mercy. The sheer brutality of the act and the innocence of the victims left the Palm Beach County community stunned and outraged.
This process was a qualitative process and not a quantitative one. Understanding that process, this court then assigned an appropriate weight to each aggravating factor and determined they are singularly and in combination with each other more than sufficient to justify a sentence of death as to each count of first-degree murder in this case. Having determined that the proven aggravating factors are sufficient, the court then undertook the weighting of the proven aggravating factors against the established mitigating circumstances. The court finds that as to each count of first-degree murder considered separately,
Joseph's defense team emphasized his lifelong struggle with mental illness, pointing to a history marked by an abusive childhood, severe depression, PTSD, and numerous suicide attempts. Psychiatrists testified that he had received mental health treatment on and off since early childhood, but the prosecution painted a very different picture, one of deliberate and calculated violence. They argued that Joseph was fully aware of what he was doing and that the murders were not driven by a mental breakdown, but were instead cold, intentional executions. In the end, the jury sided with the prosecution.
Your right to live at all. Accordingly, it is hereby ordered and adjudged that, as to count 1, for the first-degree murder of Claude Crowell, Marlon Luis Joseph shall be delivered into the custody of the Florida Department of Corrections at the Florida State Prison. You shall be confined there until a date certain selected by the governor of the state of Florida, and on that date you shall be executed in a method provided by Florida law.
Joseph's attorneys portrayed him as a man tormented by years of mental illness, citing an abusive upbringing, chronic depression, PTSD, and repeated suicide attempts. Expert witnesses testified that he had been receiving mental health treatment since childhood, but prosecutors rejected this explanation, presenting him instead as fully aware and in control of his actions. They argued the murders were not the result of a psychological crisis, but calculated, cold-blooded killings. Ultimately, the jury agreed with the prosecution's version of events.
This video you'll see only on 5. Police escorting Marlon Joseph, the man accused of murdering a West Palm Beach mother and daughter, into the police department.
In 2007, Dexter Johnson was sentenced to death at just 18 years old for his involvement in a chilling double murder in Houston, Texas. The crime took place a year earlier, when Johnson and 2 accomplices abducted Maria Aparici and her boyfriend, Huey Nig, during a carjacking. Holding the couple at gunpoint, they drove them to a secluded location where Johnson ultimately ordered their execution. Despite the victims' desperate pleas, Johnson showed no mercy. Investigators labeled him the ringleader, and his emotionless behavior during the investigation only deepened the community's outrage over the brutality of the crime. During the trial, Johnson's defense team argued that he had significant intellectual impairments. They presented records showing his low IQ, poor school performance, and a long history of behavioral problems beginning in childhood. The defense claimed that executing him would violate the 2002 Supreme Court ruling in Atkins v. Virginia, which prohibits the death penalty for individuals with intellectual disabilities. However, prosecutors countered that Johnson did not meet the legal threshold for such a diagnosis, and pointed to his ability to plan and lead the crimes as evidence of his mental competence. Johnson's case continues to be at the center of ongoing debates about the death penalty and mental capacity. Critics argue that the legal standard for determining intellectual disability is too limited and doesn't adequately safeguard vulnerable individuals. Many also question whether someone as young as Johnson should ever be eligible for capital punishment, especially given that brain development is still underway during adolescence. He remains on death row in Texas, and his case is frequently cited by advocates pushing for reform in how the justice system treats juveniles and those with mental impairments facing execution. At just 14 years old, Aiden Fucci committed one of the most horrifying crimes in Florida's recent memory. In 2021, he brutally murdered his 13-year-old classmate Tristan Bailey. Both attended Patriot Oaks Academy. Fucci lured Tristan into the woods near their neighborhood, where he stabbed her a staggering 114 times. Her body was later found in a remote area. What shocked the public even more was a Snapchat post Fucci made before the attack, posing with a knife and wearing a chilling smirk. The image quickly went viral, serving as a disturbing and crucial piece of evidence.
We're having fun in a f***ing cop car.
Yep. Tristan.
What's up, guys?
Yep.
Tristan, if you f***ing walk out the damn...
When you see this in a month...
I would submit that this case is probably the most difficult and shocking case that this county in St. Johns County has dealt with. In the 20 years that I have been, or 16 years that I have been practicing law.
Despite being only 14, prosecutors charged Fucci as an adult because of the brutal nature of his crime. The case sparked urgent legal and ethical debates about how society should handle violent minors. While the Supreme Court's ruling in Roper v. Simmons prohibits the death penalty for juveniles, Fucci still faced the possibility of life imprisonment. His case reignited a nationwide conversation about juvenile crime, brain development, and whether teenagers can truly understand the full consequences of their actions.
The Snapchat you did was not very smart. Now we have people want to burn our house down or curse them. Because of that Snapchat thing you did. It's all over, you're all over the internet and everywhere. Social media. It's on social media. You'll probably come stay with me after we get done with this. Just for your well, safe being. This is serious. It's very serious. joke. This is your whole life. Your whole life.
And hers.
And ours. And your brothers and sisters. And don't forget they go to school wrong. Because the kids will harm you.
In 2023, Fucci pleaded guilty to first-degree murder. During sentencing, Tristan Bailey's family gave heartfelt victim impact statements, expressing the profound grief over the loss of a bright and loving young girl. The court sentenced Fucci to life without the possibility of parole, concluding that despite his youth, the crime was so brutal and planned that rehabilitation was not an option. His case has since become a landmark example of the limits of juvenile sentencing and the complex challenge of balancing justice, reform, and public safety.
What's going on? I don't let you demons. I don't let you demons take my soul. You demons want to take my soul away. I don't let you demons steal my soul. I don't know what's going on. What's going on? I see my face. What's going on? What we got going on? Why am I here? I just want to talk to my mom and dad. What's going on? What's going on? What's going on? What? I used to. Why are all these changed?
The parents were okay. And Mr. Fucci just wanted to make a short statement.
I just want to say I plead out guilty, and that I'm sorry for the Bailey family and my family.
Okay. I'm sure that there'll be an opportunity, obviously, at sentencing hearing to speak again at that time, okay?
Yes, sir.
Nikolas Cruz was 19 years old when he committed the devastating mass shooting at Marjorie Stoneman Douglas High School in Parkland, Florida, in 2018. Armed with an AR-15 style rifle, he killed 17 students and staff members and injured 17 more. This tragic event stands as one of the deadliest school shootings in U.S. history. Cruz had a well-known history of violence and mental health struggles and had been expelled from the school prior to the attack. Disturbingly, he made no attempt to flee or hide his identity, making it clear he intended to carry out the massacre.
Previously waived, then there was some discussion about whether it could be in a death penalty case, but the defense is maintaining their waiver of a PSI. Mr. Cruz, you're still under oath. Are you in agreement that you're not asking for a PSI in this case? Okay. Is there anything else? Or he's remanded to the custody of the Department of Corrections. And he's to be given credit in the amount of 1,718 days time served.
Following his arrest, Cruz confessed to all 17 murders. In 2022, a sentencing trial was held to determine if he should face the death penalty. Despite prosecutors pushing for execution, the jury was unable to reach a unanimous verdict, which is required under Florida law. As a result, Cruz was sentenced to life in prison without the possibility of parole. This decision sparked outrage among many survivors and family members, who felt that justice fell short considering the magnitude and horror of the crime.
You don't know me, but you tried to kill me. I will have a scar on my arm in the memory of you pointing your gun at me, ingrained in my brain forever. The person I was at 2:20 on Wednesday, February 14th, 2018, is not the same one who stands here today. I am broken and altered.
The case reignited intense national debates surrounding mental health care, school safety, and the use of the death penalty for young adults. Cruz's defense argued that years of neglect, trauma, and mental illness had shaped him, claiming his neurodevelopmental disorders impaired his impulse control. However, critics insisted that the brutal killing of 17 innocent people warranted the severest punishment. Cruz's case underscores the complicated balance between youth, mental illness, and responsibility in cases of mass violence. Jonathan Belton was just 16 years old when he was convicted of killing Detroit police officer Larry Nevers in 2004. Alongside an accomplice, Belton ambushed the officer during a confrontation and fired multiple shots. Despite Officer Nevers' efforts to defend himself, he succumbed to his injuries. The bold attack shocked both the local community and law enforcement throughout Michigan. Belton was swiftly arrested, tried as an adult, and found guilty of first-degree murder, receiving a life sentence without the chance of parole.
Court getting off to an interesting start when Oakland County Judge Ray Lee Chabot warned attorneys that if anyone used the word polygraph, as Jeffrey Feiger did on Monday, they'd be going to jail. Polygraphs are not allowed in Michigan courts, and referencing them isn't permitted either.
If the word polygraph is used in this trial again, either by Mr. Feiger or Mr. Frazee or any of their witnesses, I am going to grant the mistrial. I will swear out contempt, and the sanction isn't going to be money, it's going to be jail.
At the time, it was common for juvenile offenders to receive life sentences for serious crimes. However, Belton's case later played a role in a significant legal shift. In 2012, the U.S. Supreme Court ruled in Miller v. Alabama that mandatory life without parole sentences for juveniles were unconstitutional. The decision recognized that young offenders have a greater potential for growth and that their age and maturity must be considered during sentence. After the Supreme Court's ruling, Belton's sentence was reconsidered. While his conviction stood, the courts were now required to evaluate whether a life sentence was appropriate given his age, background, and potential for rehabilitation. His case contributed to a nationwide movement toward re-examining the sentencing of young offenders, particularly regarding life imprisonment. The Miller v. Alabama decision has had a lasting impact, offering thousands of juveniles serving life sentences the opportunity for a second review.
And Mr. Fucci just wanted to make a short statement.
I just want to say I plead out guilty. That I'm sorry for the Bailey family and my family.
I'm sure that there'll be an opportunity, obviously, at sentencing hearing to speak again at that time. Okay?
These cases are a grim reminder that even the youngest among us are capable of unimaginable violence, but they also challenge us to consider how we define justice. Should age be a shield against the harshest penalties, or are some crimes so severe that even youth offers no excuse? Let us know in the comments what you think. Should teens ever receive the death penalty, or is there always room for rehabilitation? Don't forget to like, subscribe, and hit the bell icon so you never miss a deep dive into true crime and courtroom drama. Thanks for watching.